Today's civil case centers on a visitor who went to a homeowner's garage to inspect a speaker for sale. When the homeowner opened an interior door to move a large dog inside, a smaller terrier rushed out and bit the visitor's lower leg. The visitor presents wound photos and a medical report. The homeowner describes it as a minor nip and says the visitor stood too close and reacted loudly. The court examines duty to control animals, foreseeability, proximate cause, and the reasonableness of medical costs versus any claim for punitive damages. We'll follow the testimony, exhibits, and arguments to see who is legally responsible and what compensation, if any, is awarded. Clerk says, "All rise. Civil Courtroom 3 is now in session." The Honorable Judge presiding, Judge says, "You may be seated." Calling the matter of plaintiff versus defendant, a civil action seeking compensatory and punitive damages arising from a dog bite incident. Appearances for the record, plaintiff says, "Good morning, Your Honor." Plaintiff appearing self-represented. Defendant says, "Good morning, Your Honor." Defendant appearing self-represented. Judge says, "Thank you. This is a bench trial. Please answer only the questions asked. Do not speak over one another, and wait for rulings on any objections. We will proceed with brief openings, then testimony, exhibits, and argument." Plaintiff, your opening statement. Plaintiff says, "Your Honor, I went to the defendant's residence on December 29, 2015, to view a speaker she had listed for sale. The garage door was fully open when I arrived, and two large dogs were visible inside the garage area. Those dogs did not bite me. While I was there, the defendant opened the interior door that leads from the house into the garage. A smaller dog, an Australian Terrier, rushed out through that doorway and bit me on the lower leg. I sought medical care the same day, received treatment, and documented the injuries with photographs. I am asking the court to award my medical expenses and a modest sum for the injury and inconvenience, and I initially requested punitive damages because the incident was preventable. I will present photos, a doctor's report, and the timeline showing the bite occurred as a direct result of the defendant opening the house door without securing the dog that came through it." Judge says, "Thank you, defendant. Your opening." Defendant says, "Your Honor, I am sorry there was an incident, but I disagree with how the plaintiff describes it. He asked me to put my Saint Bernard inside the house because it was barking. I opened the door to move that dog, and I asked the plaintiff to remain on the driveway and not step into my garage while I handled it. He came closer, got behind me, and when he startled and yelled, the small dog came out and nipped him. I do not believe this was a true bite that broke the skin in a serious way. I believe it was a brief nip. I also believe the plaintiff's actions contributed because I asked him to keep his distance while I dealt with my dogs." Judge says, "Understood. We will take testimony under oath." Plaintiff, please come forward. Clerk says, "Please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter will be the truth, the whole truth, and nothing but the truth?" Plaintiff says, "I do." Judge says, "You may testify." Plaintiff says, "I drove to the defendant's home the afternoon of December 29, 2015, after communicating about a speaker she was selling. I parked in the driveway. The overhead garage door was already up. Two large dogs were present inside the garage area. They were near the back and to one side. I remained calm and did not approach or touch them. We exchanged greetings, and I asked to take a closer look at the speaker. The defendant and I stood within view of the open garage. I was near the threshold at the front where the driveway meets the garage floor. At that point, because one of the large dogs was barking, I asked whether she could put that dog inside the house so I could safely view the item. She agreed and went to the interior door that opens into the house. She opened that door. As soon as it opened, a smaller dog I had not seen before rushed from the interior of the house into the garage and came straight toward me. In a split second, I felt sharp pain on my lower leg. I looked down and saw the small dog at my calf. I stepped back and said that the dog bit me, There was a mark and broken skin. Judge says, where exactly were you in relation to the garage at the moment of contact? Plaintiff says, I was at the front edge of the garage, about a step inside the threshold. As I looked at the speaker placed nearer to that area, I had not gone deep into the garage. My path was toward the item she was selling. I was not moving toward the door to the house. The small dog came from the doorway behind the defendant and then toward me. Judge says, describe the injury. Plaintiff says, it was a bite to the lower left leg, just above the ankle on the outside of the calf. It left a puncture and superficial tearing with redness and swelling. It bled. I took photographs at the scene and again later that day. I cleaned the wound and, because it was a dog bite, I sought medical care the same day to reduce the risk of infection. Judge says, did you receive medical treatment? Plaintiff says, yes. The clinic cleaned the wound again, applied antiseptic, updated my tetanus vaccination, and prescribed antibiotics as a precaution. They provided instructions for monitoring for infection and for changing the dressing. I have the medical report and a bill showing the expense. Judge says, did you notify the defendant about your medical costs? Plaintiff says, yes. I had an attorney contact her to discuss a resolution. We asked for a meeting to handle the medical expenses and a small amount for the injury and inconvenience. There was no resolution at that time, and that resulted in today's hearing. Judge says, do you have photographs and the medical documentation? Plaintiff says, I do. I have printed photographs of the bite, taken shortly after it happened and later that day, and the medical visit summary and invoice. I have marked the photographs as Plaintiff S Exhibit 1 and the medical report and bill as Plaintiff S Exhibit 2. Judge says, give those to the clerk. Clerk says, exhibits received. Judge says, defendant, any objection to Exhibit 1? The photographs. Defendant says, no objection to the pictures, Your Honor. Judge says, Exhibit 1 is admitted. Any objection to Exhibit 2? The medical report and bill. Defendant says, no objection to the documents, but I disagree with the idea that it was a serious bite. Judge says, objection to admissibility is overruled. Exhibit 2 is admitted. Plaintiff, please describe what the photographs show. Plaintiff says, the first image shows the outer lower leg with a fresh bite mark and surrounding redness. You can see a crescent-shaped area where the tooth made contact and a small puncture site. The following images show the same area later that day with swelling and bruising, and a final image of the dressing applied at the clinic. The medical record notes a dog bite to the lower leg, wound cleansing, tetanus booster, oral antibiotics, and follow-up guidance. Judge says, did the defendant or anyone else dispute at the scene that contact had occurred? Plaintiff says, no. The defendant acknowledged that her small dog came through the door. She was focused on consoling the dog that had been barking and then realized the smaller one had run out. I told her I had been bitten and needed to get treatment. She expressed that she was sorry the incident occurred. Judge says, did you do anything to provoke the dog? Plaintiff says, no, I did not touch any dog. I made no sudden movements toward the doorway, and I did not attempt to pet or engage the dog. I was simply standing near the front of the garage to view the item I had come to see. Judge says, did you scream? Plaintiff says, I said loudly when I was bitten, but I did not scream before the bite. The shout came after the bite and was a reaction to pain. Judge says, you may step back for cross-examination. Defendant says, thank you, Your Honor. Plaintiff, didn't I ask you specifically to stay on the driveway while I moved the St. Bernard? Plaintiff says, you did say you were going to move that dog into the house. I remained at the front edge, where the driveway meets the garage. I did not go deeper into the garage. Defendant says, when my dog barked, didn't you shout loudly, which can agitate dogs? Plaintiff says, I reacted after I was bitten. I did not shout before the smaller dog appeared and made contact. Defendant says, isn't it true you asked me to open the door to move the large dog inside, and that if you had not made that request, I would not have opened the door and the small dog would not have come out. Plaintiff says, I asked you to secure the barking dog so I could safely view the speaker. You chose to open the door to the house. Whether to open, how to open, and how to secure the interior dog were within your control as the homeowner and owner of the dogs. I did not handle the door or any animal. Defendant says, the small dog did not clamp down. It barely made contact. Would you agree it was a nip? Plaintiff says, the photos and the medical records show broken skin and a puncture wound. Whether one calls it a bite or a nip, it was contact that caused injury. Defendant says, no further questions, Your Honor. Judge says, Plaintiff, anything brief on redirect? Plaintiff says, only to clarify that I did not advance toward the interior door. The small dog came out to me when that door was opened. Judge says, understood. Defendant, please come forward to be sworn. Clerk says, please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter will be the truth, the whole truth, and nothing but the truth? Defendant says, I do. Judge says, you may testify. Defendant says, the plaintiff came to buy a speaker. My garage was open. Two large dogs were visible. One was a Saint Bernard, and the other is also large. They were in the garage. The plaintiff asked me to put the Saint Bernard inside because it was barking. I told him to please stay on the driveway and not to come into the garage while I moved the dog. I turned to the interior door, unhooked the Saint Bernard, and opened the door. The small dog, an Australian Terrier, was on the other side. When I opened the door, I heard the plaintiff make a loud noise. The terrier came out, and there was a brief moment of contact with his leg. I believe it was a nip, not a full bite. The small dog is current on vaccinations. I tried to calm everyone down and told the plaintiff I was sorry. I also felt that, if he had stayed on the driveway and not moved closer, and if he had not yelled at that moment, this would not have happened. Judge says, when you opened the interior door, did you physically restrain the terrier? Defendant says, no, Your Honor. I was focused on the Saint Bernard and did not expect the terrier to bolt through the opening. Judge says, when you opened the interior door, did you know there was a chance a dog inside the house could run into the garage? Defendant says, I did not think it would happen so fast. The terrier is small and quick. I did not anticipate it. Judge says, did the plaintiff touch or grab any dog before the contact? Defendant says, no, Your Honor. He did not touch any dog. Judge says, did the plaintiff's vehicle or body cause any dog to be trapped or harmed before you opened the door? Defendant says, no. Judge says, did you instruct the plaintiff not to enter the garage? Defendant says, I told him to stay out on the driveway. He was close to the threshold. He was behind me when I turned to open the door. Judge says, you may step back. Plaintiff, any questions for the defendant? Plaintiff says, just two. First, you acknowledge that you opened the interior door while I was at the front of the garage. Defendant says, yes. Plaintiff says, second, you acknowledge that the terrier came through that door and made contact with my leg. Defendant says, yes. Plaintiff says, no further questions. Judge says, the record reflects the parties' accounts are largely consistent regarding the sequence. The garage door was open. Two large dogs were visible in the garage, at the plaintiff's request to secure the barking dog. The defendant opened the interior door to move that dog. A smaller dog, previously inside the house, came through the doorway and made contact with the plaintiff's leg, causing injury. The dispute is primarily over characterization, bite versus nip, the extent of injury, and whether the plaintiff's location and reaction contributed to causation. We will address exhibits. The photographs show fresh injury and later swelling. The medical record documents wound cleansing, a tetanus booster, and antibiotics. Defendant, do you dispute that the plaintiff incurred medical expenses for this injury? Defendant says, I do not dispute he went to the doctor, but I believe it was a minor incident. Judge says, The court will allow brief closing statements. Plaintiff says, the facts show the contact happened immediately after the interior door was opened. I did not provoke the dog. I simply stood at the threshold to view the item for sale. The homeowner chose to open the door without securing the small dog on the other side. It was foreseeable that an unsecured dog could bolt into the garage where a visitor was present. The photos and medical records show a real bite injury, not a trivial brush, and I had to obtain medical care. I asked the court to award the medical costs and a reasonable sum for the injury. As to punitive damages, while I initially requested them to emphasize preventability, I recognize that punitive awards are reserved for especially reckless or intentional conduct, and I defer to the court's judgment on that question. Judge says, defendant. Defendant says, I am sorry he was hurt. I did what he asked by putting the big dog inside. I warned him to stay on the driveway. He moved closer, and his loud reaction escalated the situation. The small dog's contact was brief. I do not think this should be treated like a serious attack. I asked the court to take those facts into account. Judge says, thank you. The court will render findings on the record. The legal questions are liability and damages. As to liability, owners and custodians of dogs have a duty to exercise reasonable care in controlling their animals, particularly when a visitor is present. In many jurisdictions, a dog owner is strictly liable for injuries caused by a bite. In others, negligence principles apply, focusing on foreseeability and reasonable precautions. In either framework, the essential causal chain here is clear. The defendant opened the interior door. An unsecured small dog rushed through that doorway into the garage, and the dog bit or, using the defendant's word, nipped the plaintiff's leg, breaking the skin and causing a medically treated wound. The plaintiff did not touch the animals, did not approach the interior door, and did not engage in conduct that would constitute provocation. Even accepting that the plaintiff stood near or a step inside the garage threshold, that position does not absolve the defendant of responsibility for opening a door from a house containing an unsecured dog into a space where a visitor stood. The defendant controlled the door and the animals. The risk that a dog, large or small, might bolt through an open interior doorway is foreseeable. Reasonable care would include verifying the location of the interior dog and restraining it before opening that door into an occupied area. Judge says, the defense argues that the plaintiff's presence at the garage threshold and his reaction contributed to the incident. The record shows the plaintiff's loud reaction came after the contact. The defendant's suggestion that fear or a startled reaction provoked the dog is not persuasive on these facts, because the critical moment was the opening of the door with an unsecured animal on the other side. The plaintiff's location near the item for sale is natural in a sale scenario and was within the area impliedly open to him. The court does not find comparative negligence on this record. Judge says, as to the characterization of the contact, whether labeled a bite or a nip, the injury involved broken skin and a puncture that required medical attention. The photographs and the medical report corroborate that reality. The law compensates the injury and a reasonable response to it. The semantics are not controlling. The court is satisfied that the plaintiff required and reasonably obtained medical care, including wound cleansing, a tetanus booster, and antibiotics, and that he experienced pain, bruising, and swelling in the aftermath. Judge says, turning to damages, the appropriate measure is to make the plaintiff whole for losses proximately caused by the incident. The medical record and invoice support the costs incurred. The plaintiff has not presented evidence of wage loss or long-term impairment. The injury appears to be a modest but real bite that healed with standard care. A reasonable award includes reimbursement of medical expenses and a modest sum for the disruption, discomfort, and the immediate aftermath of treatment. Punitive damages are reserved for willful, wanton, or malicious conduct or gross disregard for safety. While the court finds that the defendant failed to exercise adequate control over her animals when opening the interior door, The conduct does not rise to the extraordinary level required for punitive relief. The punitive request is therefore denied. Judge says, judgment is entered for the plaintiff in the amount of $500. This figure reflects the medical costs and a modest allowance for pain, inconvenience, and the time and effort required to obtain and comply with treatment without venturing into punitive territory. Payment shall be made within the time provided by the rules of court. The request for punitive damages is denied. All other relief not expressly granted is denied. Plaintiff says, "Thank you, Your Honor." Defendant says, "Understood, Your Honor." Judge says, "Before we adjourn, I will briefly explain the evidentiary considerations." The contemporaneous photographs depict a fresh wound with surrounding redness and then subsequent swelling and bruising. The medical documentation establishes that standard care for a dog bite was provided, including prophylactic antibiotics and a tetanus booster. The defendant acknowledged opening the interior door while the plaintiff stood at the threshold and that the small dog came through and made contact. Those facts, taken together, establish causation and a breach of the duty to control animals when opening a portal between private interior space and an area where a visitor stands. Arguments about whether the plaintiff stood on the driveway or a step inside the garage do not break the causal chain in this context. Assertions that the plaintiff's post-contact vocal reaction contributed do not negate the precipitating event. For these reasons, liability is found and damages are awarded as stated. Clerk says, judgment for the plaintiff in the amount of $500 will be entered. Copies will be made available. Parties may step forward after adjournment to receive paperwork. Judge says, is there anything further? Plaintiff says, nothing further, Your Honor. Defendant says, nothing further, Your Honor. Judge says, very well. Court is adjourned. Clerk says, all rise.